So, hey, welcome. Thank you all very much for joining us. We are happy to do this. So I'm Brian Kabateck, and this is Shant Karnikian, who's my co-presenter tonight, partial co-presenter. For those of you that don't know me, I am currently the president of the LA County Bar. I've been the president of the Consumer Attorneys of California, which is the plaintiffs' bar in trade organization in Sacramento, lobbying organization up there. And I'm also the chairman of the board of Loyola. How many people do we have here tonight who graduated from Loyola Law School? Yes. Outstanding, fantastic. And the reason I mention that is because one of the reasons we do this is because I do believe strongly in giving back, and I like the fact that I can educate people and hopefully share some ideas with folks. Obviously, the other reason is we're always interested in working with lawyers, and we want lawyers to know where our specialty is or what we do. With me tonight is Shant Karnikian. Shant is also a graduate of Loyola Law School. We do hire other people besides Loyola graduates every now and then. But Shant and I have tried about 6 cases together, including one that Natalie, who's back there, Natalie, Shant, and I tried it was the longest trial of my career. It started on September 11th and ended on November 27th with a $40 million verdict on a mobile home case, not an insurance case, but a mobile home case for 30 of our 150 plaintiffs. So we have another 120 to go. But maybe we'll have a seminar sometime later this year to talk about what we came out of that trial, what we learned from a 11.5-week trial, besides the fact that you get no sleep, your family forgets your name. And at some point, I was staying downtown during that trial, and at some point, my wife actually suggested when I had a light week, she said, no, you'd actually be happier staying downtown. And I said, no, I can come home. She said, no, you'd be happier. What should I read into that, Annie? So what we're going to do tonight is we're going to talk about insurance, bad faith, insurance itself. I realized in putting this program together, I've done this before, some similar program before. I've realized that this is truly like a 6 to 8 hour seminar. It could be, because it's such a deep subject. I have done probably as many insurance bad faith property cases, bad faith trials, than anybody in California at this point, or as many as at least anybody. And I've tried other types of bad faith cases too, but I like bad faith, I like insurance. I know that makes me a little bit of a geek, but it's really interesting subject. I think it's interesting, I think it's nuanced. I also think that my good friend Jeff Ellis is sitting here tonight making me a little uncomfortable because he's one of the finest coverage lawyers I know. And it is a manageable subject, but to most lawyers who don't do this on a regular basis, it's sort of like Martian. It's very foreign in a lot of respects, and I don't think it is that difficult to master. But you inevitably will come into, particularly young lawyers here, at some point in your career, you will come in contact with insurance issues that you don't completely understand. Feel free to pick up the phone and call us. So let's get started, Shant, by just talking initially about the different types of insurance.
So first we have, even though it says third, we're going to start with that, third-party coverage, because this is generally how people tend to think of it in terms of prevalence of them coming across it when they're doing other practices like PI and stuff. So the first-party coverage is coverage provided for liability of the insured to another. So you have a injured party. The third-party coverage you're seeking is for the tortfeasor's, you're seeking it from the tortfeasor's insurance coverage. So that's what that is. So typical auto cases, general liability when you're injured on somebody's property or something like that. Professional liability for whether it's lawyers, med mal, things like that. And D&O when you have an executive or someone, leadership position in a company that screws something up, for lack of a better term. The next area we're going to cover is first-party coverage, and that's when the insured, your client, or whoever the person that's been harmed is, makes a direct claim to their own insurance carrier, under their own policy. So property insurance, the house is damaged, uninsured motorist, underinsured motorist, you're injured, other side doesn't have coverage. You're making the claim with your own carrier. And then life, health, disability, typical claims that you take out a policy for yourself, you're making a claim on that policy, not through somebody else's policy. So I think first we're going to talk about the types of damages that are available just generally under insurance cases, bad faith cases. So of course, first we have contract damages, and that's kind of basic. And in order to prove that, you need breach, and you need damages, of course, which are the contract remedies. That
Let me drill this home to you, though. If you do not have a valid breach of contract in some way, in some form, you will never get to a bad faith case. You must have a breach of contract. So as bad as you think the insurance company might act, as their behavior might be, you have to find that there's some kind of breach. Now, breach can happen in three important ways. The easiest and the best is they've wrongfully denied coverage. We didn't put the word wrongfully in there, but they've wrongfully denied coverage. So there is coverage and they denied it. The reason I like that case the best is because it underlines the fact that the insurance company has stiffed you. The insured is sitting there having a claim that's unpaid. They haven't been compensated, so they've been stiffed. The second one is they pay something, but they don't pay all of it. So now you're fighting over really what's owed, how much is owed. They think they paid enough. You don't think you've paid enough. Not a bad case. The most difficult case you're going to find is a case where the insured's paid. They've paid. Maybe there's a delay. You're arguing over delay, but they paid the claim. And those are the cases that I would red flag, because if the case like that comes in and says, I've got a problem, we're going to talk about this with underinsured and uninsured motorists a little bit later. But if an insured comes in with that situation and they say that they've been fully paid, you need to think long and hard about whether or not you want that case, because now you're trying to argue about additional damages, what happened to the person as a result of that.
So bad faith in general, and going back to what Brian said, the contract, you need the breach. That's a threshold requirement. No matter how bad the conduct is, if you ultimately aren't going to be able to prove breach, you can't get to bad faith. So bad faith is when they've acted unreasonably and without proper cause. That's, again, after you pass the question of did they breach the contract, did they not comply with what the policy requires for them to do. And also, a lot of people are mistaken about this. It's not a fiduciary relationship, so you are not the paramount thing that they need to consider when making their decisions. However, they have to give you kind of equal footing or equal consideration. So it's a delicate balance there. It's not a fiduciary relationship, but they do have to give you equal consideration. A key question that we're going to keep going back to over and over again throughout this presentation is going to be unreasonable, whether or not they're acting reasonably.
But let's focus on this for just one more moment. It is not your typical contract. In your typical contract, you do not have to give equal consideration to the other party as you give to yourself. In an insurance situation, you do. And one thing I use an opening statement in a jury with juries is I explain that the uniqueness of an insurance relationship is unlike any other contract, because unlike any other contract, you can't replace the contract once an event has occurred. So the house is burned down. You can't go out and find insurance to insure you after your house is burned down. So the insurance company has to put themselves on the same level with you. They can't put their interests ahead of yours. A lot of people think it's a fiduciary relationship. It's not. But ultimately, you can go to the next slide, it's okay. But ultimately, it's whether or not, the question for bad faith is whether or not the insurance company acted reasonably. It's not negligence. It's not fraud standard, but it's not negligence. So merely getting it wrong isn't enough. It has to be whether or not the insurance company acted unreasonable. For some reason, defense lawyers, defendants, insurance companies like the other standard, which is without proper cause. I always think that's because it's harder for a jury to get their head around that notion of without proper cause. So I constantly hit on this. Was the conduct unreasonable? It was unreasonable. Is that what a person would think that was reasonable under the circumstances?
So a threshold question I think Brian has instilled in me to look at before we take on a case or not is the plaintiff likable? Like all the other threshold questions about is there a breach, equally important is the plaintiff likable? Is the jury going to hate your plaintiff? Because ultimately at the end of the day, what you're pursuing is not a claim against the party that caused the harm or did the wrong. You're pursuing an insurance company, especially in a third-party case. You're going after the other side's insurance company. You're not going after the person that crashed into you or the person that caused whatever injury your client is suffering from. So you have to make sure that your client is likable enough where they're not going to look at it and go, well, he's a jerk, and it's not like they're suing the person that hurt them. They're just suing this company, this kind of faceless entity. So you got to make sure that that's the first question you look at.
Look, I want to use two examples of this. One is a case that Shant and I tried about 18 months ago, where we had a single father of 5 who had been taken advantage of by his insurance company. They hadn't fixed the home. His story was likable. His son, the youngest one in the family, I think had epilepsy or something like that. And he was extremely likable. That helped. I have 2 examples I can give, but I'll use the one, we'll call him Mr. Burt. I tried a case with Mr. Burt. I didn't like Mr. Burt. I didn't like him at all. In fact, I spent 3 days with him preparing him for his direct examination in this case. And after his direct examination, I sat down and my co-counsel turned to me and he says, "My God, you're a miracle worker. You've really made this guy likable." Unfortunately, 40 minutes into the cross-examination, I knew for the first time in my life what the phrase, "I want to crawl under the table," really means, because he unwound and because he was not likable. And when we won the contract damages in that case, but we didn't get bad faith, and the jury said, their quote was, "Mr. Burt is the kind of guy who steps on little people, and we're little people." And they were right. That's who he was. And I was a young lawyer at the time, and I didn't recognize the fact that you can't sometimes put lipstick on a pig. And that's what the problem is. And the reason that Shant's bringing this up is in these bad faith cases, you're dealing oftentimes with an insurance company who's going to say that your insured was difficult to deal with, there was a problem in dealing with him, we didn't cause the loss in the first place, the loss was the fire that burned his house down or the accident or whatever, and you really have to make sure that your plaintiff's likable, because if your plaintiff isn't likable, that's what they're going to hold their hand, they're going to grab a hold of in trial, and they're going to point out what an unlikable person he is or she is.
So controlling client expectations is also really important.
Does that look like an airplane meal? Because I was looking at this slide earlier today, and I flew last weekend someplace, and I thought that looks like the meal they served me on the airplane.
Yeah, and oftentimes your clients do have some crazy expectation about this because it's an insurance company. Again, it's a faceless entity that they've been paying money to, and they think they're going to go in there and get every dime out of them, and these people really screwed me. And sometimes it's misplaced anger. Sometimes it might be justified, but you need to control their expectations, much like you do in every case. But also specifically in these types of cases, because as Brian mentioned, it's 2 separate questions when you get to breach of contract and bad faith. Literally on the verdict form, you're often going to end up with 2 separate questions. The threshold question of was there a breach, and then did they act unreasonably, or it could be phrased in different ways. So they need to understand that this isn't the jackpot, it's not the lottery that they're playing, and at best they're going to get their contract benefits and something else on top of it in most circumstances, unless you go into this big killer trial. You got to control their expectations. So that's what I think I'd say about that. And this is a favorite saying of Brian's, and he came up with this kind of graphic here. Pigs get fat, hogs get slaughtered. I think it just means you can't be greedy. Like I said, the party you're going after, the insurance company, especially in third-party cases, isn't who caused the injury. So
and also another reason that this is important is because insurance policies in them inevitably have a number of clauses, and one of the clauses is that if you willfully misstate any part of the claim, you've overstated the claim, that the entire claim can be rejected or denied. And the other is there's a cooperation clause in policies, which mean you have to cooperate with the insurance companies. And when people get piggish or hoggish, they really go overboard in what they're trying to get. I mean, we had a case recently come into the office that we rejected where the insured wanted to make a claim for every item that they owned, every personal property item that they owned in their home, even though it had, and did make that claim with the insurance company, even though it hadn't been damaged by the fire, they just thought that they should get new everything because there was a fire. And that's incredibly hoggish and makes them look bad. In fact, I think misrepresents their policy, which could get their entire claim denied. We rejected that claim. Yes, sir.
So what if it's a personal item like family photos?
Well, the first question, though, was it destroyed? I mean, whether or not it has value is another question. But what I'm saying is people have to make claims for things that were actually damaged or destroyed because that's covered under a first party. You're now talking about first party property insurance. So they have value. You have to figure out a way if they're replaceable or not replaceable. But even if they're not replaceable, they may have value. But if they aren't destroyed at all, then you're overstating the claim.
Right, sorry, I should have clarified. If it is damaged and it is personal items such as family photos or something like that, and they value them a certain way, how do you avoid getting into the slaughterhouse?
Well, right, you got to be careful about that. I mean, you know, they may be very important to them, but what's their actual value, and are they replaceable? There are companies out there that sometimes replace them, but if they burn, what's the value of a photograph that can't be replaced? It's not $1 million.
Yeah. And by the way, those types of actions, being hoggish, as we refer to it, can destroy an otherwise great case.
Yep.
You know, you might have a very valid point in your claim, and you know, actions like that might just kill everything else.
Okay, so I'm going to talk about this. Shant, you can jump in if you have some comments during this part, but this is popping the lid off a policy, which is something that a lot of plaintiff lawyers, particularly personal injury plaintiff lawyers, are constantly talking about. And one of the seminars we want to give in the future would be much more in depth about this. It would be sort of the topic is how do you turn a huge damage but small policy limits case into a valuable case. And this is one of the ways. This is where you've got someone who's got injuries that exceed the amount of the policy limits. You've got small policy limits, and you want to make a demand under the policy for the policy limits and hope that the insurance company doesn't pay. Because if they don't pay, the general rule is they can be liable for the entire damage. But like every case and every situation we face as lawyers, there's all kinds of exceptions. So let's kind of go through this. What we're trying to come up with here is you've got this client that comes into your office. They've got fairly significant injuries. The client was hit by someone who has a $15,000 or $25,000 policy, and you know in your mind that the case is worth at least that, if not much more. So what are you going to do? Well, the first thing you need to do is make sure that you've got the amount of policy limits. And carriers generally have no obligation to give the limits outside of discovery. Sometimes they will. Sometimes the insured will tell you how much insurance they have. But once you know that you've got, if you're in litigation, they have to provide confirmation. Once you know what the policy limits are, or you have to have a reasonable belief in what they are, because you could be sued by your client if you make a $15,000 demand and the client had the other driver had a $100,000 policy, for example. So the next thing you need to do, I know this is sort of axiomatic and people probably figure it out already, get everything you can about the loss. And I know there are lawyers that will say, the injury's so bad, I'm not going to provide you with the medical records. I'm not going to provide a police report. I think people who do that are being very cute and playing a very dangerous game. Because, as I'll talk in a moment, that's one of the defenses an insurance company will have, is that you didn't provide enough information. If you've got at least a significant amount of information about the plaintiff's harm and losses, you're now on the road to being able to write that letter. Get your client's approval. I know it goes without saying, but don't make these kind of demands without the client's authorization and at least trying to confirm it in an email or letter to the client. You've authorized me to make a policy limits demand for $15,000, because the whole thing can blow up later if it turns out you never had their consent. And I've had clients, by the way, who will say to me, that's not enough money, which they're probably right, and I want you to go after the insured personally. And I think it's your responsibility as a lawyer to tell them that unless it's a high net worth individual who is underinsured, more often than not, they can file bankruptcy and discharge. So what's the point in trying to go after them? And I've had, grieving parents, and I remember one son adult son whose father was killed in an accident, told me, he wanted to go after and take their home and take their car. And these were relatively modest people. It was never going to happen. So you need to make sure they understand that. So your demand letter, confirm that you've got the policy limits, confirm what the policy limits are, make them confirm it in the letter. Say, I am basing this on the understanding that the policy limit is $15,000. Confirm there's no other available coverage. That's what you got to say. You got to say, I'm taking the position that there's no other available coverage under the policy, that the defendant was not in the course and scope, or some other way that other possible insurance or possible defendants might be liable for the accident. You need to make sure of that. Then you want to say that you're going to offer to accept the policy limits in exchange for a full release. This is important because the insurance company we're dealing with here is not your client's insurance company. It's the insurance company of the responsible party, the third party. And that's important because once you know that, their responsibility, the insurance company's responsibility is to protect their insured. So unless you're offering a complete release in your demand letter, they have the right to say, well, you weren't offering, complete peace to my client, to my insured. So as a result of that, we couldn't accept because you weren't taking them out of harm's way. And that's ultimately what you need to do. You're saying, I'm going to take the insured out of harm's way if you pay this. What's next? Send it by certified mail. That's my recommendation, so you have a record of it. You don't have to, but I've seen cases before where the insurance company says we never received the letter. We don't have it. You can send it by email. You can attach it as a PDF, but ask for confirmation back from them that they got it. You do not want them playing games with you and say, we never got your demand letter, and that's happened. I think 30 days, okay? I know people out there will do things like they give them 5 days to respond, they give them 2 weeks to respond. And there can be circumstances where the 2 weeks is appropriate, but be careful with that because the standard is about 30 days. And I'm guaranteeing you, if you do 30 days, no one's going to criticize you for not giving the carrier enough time. And you may get circumstances where the carrier comes back and says, we need more time, we need more time, we need to evaluate. I would not necessarily give them more time unless they have a good reason. If they say, we need more time because we need to get the following record, then you need to consider that if you didn't give them enough or provide them enough information. But 30 days is generally the right amount of time.
And by the way, I think in the packets at the end, we have like a sample or exemplar demand letter. So you can take a look at that later.
All right. Here is a substantive legal issue you need to comprehend about this whole notion of making a policy limits demand. If there is an event where multiple injured parties are making a claim under the same policy, the carrier cannot accept your demand and or cannot reject your demand. They will not be exposed to bad faith for failing to do that. Because if Shant and I are both victims in an accident, we're represented by different lawyers, and his lawyer makes a policy limits demand for the $100,000 policy, the carrier has every right to say no because they don't have my consent to it. Because what would happen then is they've exposed their insured to an excess judgment, and they can't do it, so it will not work is what I'm trying to say. You need the cooperation of the other counsel. We've had these cases before. You reach out to the other lawyer and you say, look, there's a $500,000 policy here. Let's make a single demand and tell them in the letter that we'll work it out between ourselves later, which you can. You can get a special master. You can have a preset agreement, 50-50, 40-60, whatever. But once you do that and you say, we'll give your insured the piece he or she needs in exchange for the policy limits to both of us, you're fine. But if you don't have the consent from the other counsel or your own client, if you represent both of them, then you're running a risk. Then a unified demand, like I said, it's without cooperation, it's not effective. And I've seen this situation before. It's bizarre, but I've seen it where the carrier has already paid a small amount of money out under the policy. Let's say it's a $100,000 policy limit. They paid 30 out. There's 70,000 remaining. Make sure you make it clear that you would accept the remaining amount of the policy limit in exchange for a full release. So a couple considerations here. Was there ever a response from the insurance company within the time? So they may write back to you and say, we need more information. I had one case come to me where the lawyers thought they were super cute because they had demanded the policy limits. They hadn't provided really enough information. The lawyer for the insurance carrier wrote back and said, I need more information. They were very specific. In fact, the letter started out, we're taking your demand very seriously, but we don't have employment records and we don't have the hospitalization records, and it wasn't a quad. I mean, look, if it were a quad and a $15,000 policy, that's bullshit to ask for that kind of information, frankly. That's sort of the legal definition. But if it is a large enough policy and an injury where there's questions, it's fair for them to ask. So they did ask. And the lawyer came to me and said, see here, look, I got him. They didn't respond in the 30 days. I got him. I said, well, what happened when you got this letter? He said, well, I ignored it. So you can't ignore it. I mean, that's their whole defense. It isn't automatic. This is never going to be an automatic issue. I made a demand and they failed to accept it. There's all kinds of defenses that they have. So here's what happens next. Point number one, it's not strict liability. That's what I'm trying to explain, is that this is not a bright line test. We made a demand and you didn't accept. They will claim that you failed to cooperate. I've seen this over and over again in almost every single one of these cases. We didn't have enough time. We asked for more information. They didn't provide us everything they have. We didn't have enough to understand it. This is important. This claim doesn't belong to your client. The whole purpose behind this rule is to protect the insured. The insured buys peace of mind when they pay their hard-earned money to buy an insurance policy. And so when an opportunity comes to settle within policy limits and the carrier fails to comply with that opportunity, fails to comply and fails to pay it, they've exposed their insured. It isn't to protect your client, it's to protect their insured. And by not protecting their insured, they've exposed their insured to excess judgment. So the claim doesn't belong to your client. So the next thing that has to happen is, unless the carrier wakes up and realizes they made a mistake and are willing to pay more than the policy limits, the next thing that happens is you have to go to trial. You can't enter into a settlement. You can't enter into an agreement with the defendant, okay, the case was really worth $500,000 even though you had a $15,000 policy, if they're defending. And you have to go to trial and you have to get a verdict. The only exception to that would be where they're not defending, where the carriers fail to defend, they've blown an opportunity to settle for policy limits, they're not defending, but I still recommend you go to a trial, even if it's what I kind of call like a rollover trial, where you hire a special master under 638 or 639 and have that judge hear the evidence and make a decision. It may be that the defendant makes a decision not to defend themselves in that case, but still you've got a trial that becomes a verdict that you can then turn into an enforceable type of judgment. And this is important. We'll talk about this in a moment, but there's a difference between the failure to defend and the failure to settle. There's a nuanced difference. As I said, it doesn't exist until after the verdict. You have to make a deal then with the insured. So now Shant has gotten, the injured party is Shant, he's gotten a $1 million judgment. There's a $15,000 policy. I'm the insured. I now have $1 million in judgment against me. The lawyers have got to make a deal with the actual insured now to go after the insurance company for bad faith. Most insureds at that point will be very willing to talk to you about a deal, about working something out. And you can't have a collusive deal. It has to be arm's length, and there usually has to be some kind of, I always recommend there be some sort of tickle for the actual insured, that if so much is recovered, you'll get this portion of it, but 90% of the money will go to Shant, 10% will go to the insured, because it keeps the insured interested in the case. You, the lawyer who wrote the letter in the first place, the demand letter in the first place, you, the lawyer who dealt with the insurance company, will become a witness. Beware of that, because you do not want to be a witness and be prosecuting the bad faith case. It's possible you could have somebody in your firm doing it. It's a little dangerous, but it's not unheard of. The smartest thing in the world is to go to somebody else and have them prosecute that bad faith case, because you're going to be a witness. And I guarantee you, because I have been in the hot seat before where the carrier blames me, the opening statement that the lawyer for the insurance company will make is, this case isn't about Mr. Smith here. We wanted to pay Mr. Smith. It's all about this lawyer sitting right here at the counsel table. This is all about him. So, and then they're going to put you on the stand and you're going to become a witness in your own case. So be careful of that. And this is a saying I learned as a very young lawyer: never set up an insurance company for bad faith. There are lawyers out there who believe that they can set up a company. I can set them up. I've set them up for bad faith. I've heard that so many times. Believe me, I've spent 30 years of my life dealing with insurance companies. They are completely capable of committing bad faith all on their own. They do not need your help. These are overworked people with tons of files who think they're smarter than every lawyer they've ever hired in their history. They will walk into it. The minute you start trying to set them up, it'll smell. It'll look bad. It'll look like you're trying to do something devious. Shant, you want to talk about these rules? This is the
So
law part.
there's a couple of cases that kind of control here. There's the communal case, which says that there has to be a clear and unequivocal offer to settle within policy limits. It can't just be approximately, so very clear. It just has to be clear. And that's been good law in 1958, so it's been around for a while. And then there's the, I don't know how to pronounce it, the Christie case. Christie case. You have to, the inquiry is what a prudent insurer would do. Just like how we have in law school and torts, you have the negligence inquiry of what a reasonably prudent person would do. Over here, would a reasonably prudent insurer settle within the limits, settle within the demand that you've made to them? And again, long-standing, pretty clear-cut case law on this. The Johansson case, slightly more recent, says that the question that you look to in these types of cases is whether the judgment, the exposure, is likely to exceed the amount of the settlement offer. The insurance company cannot argue, it's no defense that they reasonably or they mistakenly believe that there's no coverage. So the inquiry is only as to whether their belief about the value of the case was correct. It's not about the coverage.
Was it unreasonable for them to reject the demand at the time it was made based on the information they had? That's going to be their defense. They're going to say, we believe that the case, there wasn't liability, we believe there was a problem. That's a good defense. But the mistaken belief in no coverage is not a defense because, and we're going to talk about this in a moment, but under the duty to defend, it's one of the few bright line rules that exist in insurance law, which is if a carrier fails to defend a lawsuit, they do so at their own risk. And if they were wrong, they're going to be liable for everything. I'll get more on that later.
We talked about this earlier, just a general principle, again, from the Communal case, that they have to give the insured as much consideration as they're giving themselves. So it's not quite fiduciary, but it's not a negligence standard either. So they have to give them equal consideration. Again, I think we kind of looked at both of these cases. Christie and Johansson, those are the tests there. And the bottom line, as I think Brian articulated this earlier, is they have to protect their own insured, not the injured party, but the insured, because that's who bought the policy, not the injured party in third-party cases. And protect them, one of the things they have to protect them from is judgments in excess of the policy limit. So if they can get rid of it for the policy limits, they have to.
So as we're kind of leaving this notion, and I'm going to talk more about the duty to defend here at this point, I do want to give you an opportunity to ask questions about opening the lid on a policy, what the rules are, if anything I've said has been unclear. But let's talk about this notion. A liability policy, as opposed to a property policy, a liability policy has a duty to defend and a duty to indemnify. The duty to defend is, under most insurance policies, carriers have an obligation to defend their insured if they're sued for any claim that's covered under the policy, even if the claim itself is frivolous. So a carrier has that duty to defend. The duty to indemnify is to only pay claims which are covered under the policy at the end of the day. In other words, when there's a judgment or a settlement or whatever. Carriers usually have the right to make a decision whether or not to settle cases on their own. They usually have the right to appoint counsel. Some of the exceptions are found in legal malpractice and medical malpractice policies where there might be the right to choose counsel. But for the most part, they have the right to pick counsel. But under this duty to defend, an insurance company has to make the right decision at the beginning. Is there any possibility of coverage And if so, there's an obligation to defend. And like I said, it's one of the few areas in the law where there is a bright line rule. And the bright line rule is, if you fail to defend and there was any duty to defend, the carrier is usually liable for the whole judgment. And there's a whole line of cases where they fail to defend and what happens and how the obligation to pay for a judgment, the whole judgment exists. And the reason this rule exists is because carriers obviously are in a superior position to decide to defend you or not defend you in a case, but also there's an easy out for them if they have a question in their mind about whether or not there's coverage. They can file a declaratory relief action against their own insured with no fear of bad faith liability for filing that action. So generally, there's no bad faith for filing a dec relief, where the carrier says, look, we're not sure we owe a duty to defend, but we're gonna defend you, and in fact, we're even gonna reserve our right to get our money back if we've made the mistake. However, we're gonna file a dec relief action and have a court tell us whether or not we have an obligation to defend. That's an easy out. I never understand when I see a case or we get a case where they failed to defend and there's questions about whether or not they should defend. I never understand why they didn't defend and file a dec relief action to try to get that question resolved. The duty to indemnify comes later, and there's all kinds of nuances where they may not have to pay claims that weren't covered at the end of the case.
So this is kind of what Brian was just talking about. The under the duty to defend, if they screw that up, they're liable for the whole amount of the judgment. And under duty to indemnify, that's when they're defending, but they're saying they're not on the hook for it. They would just be on the hook for whatever they fail to pay under their duty to indemnify. And they have a duty, by now I think we've hammered this home, they have a duty to settle within policy limits when the liability is clear.
Okay, so before we go on to first party insurance, let me ask you, do you have any questions so far about opening a policy, the duty to defend, the obligations that the carrier have? Yeah.
So attorneys send the assignment letter with their settlement agreement. What are your thoughts on it? That's not on the listserv.
An assignment letter?
Yeah, so they ask the insured to assign their rights to the claimant, I guess, before the judgment. So there was a discussion on the calendar listserv between Arash and Chris Ardalan. So there was a lot of discussion about that. So Chris Ardalan was that briefly.
Yeah, I wouldn't do it. I mean, just hearing it, I wouldn't do it, and I don't know how Arash came down on that, but I think that you muck this up by putting extra conditions in there and extra issues. I think that if you're looking at this as the genuine effort to try to settle the case within policy limits, which is ultimately what a court is going to look at to decide whether or not it was reasonable. Did they make a demand to settle that was reasonable under the circumstance to try to get it settled? And so if you're sending a request for assignment saying, if the carrier doesn't pay, we want an assignment, that could be an additional condition that someone could look at and say, well, that kind of blows apart your demand. So I don't know how other people came down on that, but that's I think keep it clean. Don't try to be cute. Don't try to be clever. There are a lot of smart people out there. There's smarter people than I am. He may be smarter than I am on this issue, but I'd try to keep this clean. Yes, sir.
So I got a scenario for you.
Sure.
So this is a car accident case, pedestrian hit by a car. The police report finds that the pedestrian is at fault for running out in the street. There's a witness that says that. $50,000 policy demanded over and over and over again, never paid. Goes to trial, defense verdict on liability.
On causation.
Well, yeah, just to make it.
Negligence, no causation.
Negligence, no causation.
Okay.
So then let's just imagine that you could appeal this and maybe win the appeal, or get a new trial or something. Does the fact that the trial's been lost affect any future bad faith case, like saying, they have good reason to deny the claims because a jury already did that too?
Yeah. How's that for a short answer?
Like that'd be like.
Well, I mean, from the fact pattern, did everybody hear the fact pattern well enough? I think from the fact pattern, the problem I have with it is if we're looking at reasonable, and it's not an automatic bright line test, you just guessed wrong, then and a jury came back already with a finding that there was no liability, even if it gets reversed, the carrier is going to say, well, look, we were reasonable under the circumstances. Now, if it gets reversed and you make another demand and they don't pay, that may be a whole new ballgame.
They couldn't just point to the trial and say, well,
No, because it got reversed. So there may be, I don't know all the facts, but at that point, you're making a new demand. It may be unreasonable for them not to pay not to pay the 50. And I assume horrible injuries, right?
horrible.
What if an insurance company fails to tender the policy because their own insured lied to them about causation or how the accident happened? You go to trial and a jury decides that the plaintiff was actually not at fault. Can they cover their ass by saying, well, our insured told us that they weren't at fault for the accident, so what do you want us to do?
So the short answer to your question is no, they can't cover their ass solely by the fact that their insured lied to them. I know that's a stunning fact to us in this room here that clients sometimes lie, but it's even more stunning to insurance companies. No, insurance companies have an obligation to thoroughly investigate. That's the standard. And so obviously all facts are different, but if the fact pattern is the insured had one particular story, the third party, the injured party, had a different story, there's the injured party's lawyer submits evidence, the carrier can't turn a blind eye towards that, and they've got to look at the facts and circumstances. Of course, you're trying to protect the insured, and so if the insured himself or herself is lying, that's a factor, but they can't simply turn a blind eye towards the truth and the facts under the circumstances. And then, of course, the insured later is going to say, well, I wasn't lying, I just misunderstood, I made a mistake, I didn't know. So carriers have an obligation to thoroughly investigate. I know we had a question over here. Yes?
Well, there's a situation where there's a 100-300 policy, there's 5 people injured in a collision. 4 of them are represented by one attorney, 1 of them is represented by another attorney. The carrier ends up paying $100,000 to that one other injured party. So now you have 4 people left over with only technically $200,000 left on the policy, which would have mathematically been different if there was $300,000 left on the policy. Have they committed bad faith by just paying $100,000 already to one of the 5 people?
Arguably. There's obviously facts and circumstances. You'd have to go forward with the case and get judgments in excess of the $200,000. But it's inconceivable to me, although I've heard of it happening before, it's inconceivable to me the carrier would just simply pay that $100,000.
Right, so, well, I have this situation, but what happens now is the other 4 that still haven't been paid make demands for $100,000 each. If the carrier is willing to pay that $100,000 each, because conceivably it's $100,000 per person. So they almost make the policy limits more, and they offer the $100,000 to each of those 4 other people. Does that get them off the hook of a bad faith case?
You bet. Sure. Any other questions about this area before we move on? Yes?
I have a quick question. What if you, at the outset of your case, you make a request to your own insurance company about whatever policies are available to the insured, and they don't tell you about an uninsured motorist coverage or something like that? They say, oh, the policy limit is such and such, but they don't necessarily detail all the other options under the policy. Is that considered?
I don't completely understand the hypothetical.
Like at the outset of my case, I send a letter to my own client's insurance company asking him for the policy limits, but or whatever policies are available to the insured. And let's say they say, okay, there's this much policy, but they don't mention anything about uninsured motorists, and it turns out that there actually is an uninsured motorist coverage under the policy. Would that be considered bad faith?
It could if the insured gets in a harmful situation as a result of that. If there's no harm, no foul, if you later discover it and the uninsured motorist coverage is still available and you can still pursue the uninsured motorist coverage, then the fact that the carrier lied to you, there might be some damage for the delay, but ultimately, if the coverage is available, no. If for some reason you lose the coverage as a result of that, yeah, that's arguably bad faith. It's unreasonable conduct not to disclose. They have an obligation to disclose all coverages to their insured. Okay, so any other questions? Because I want to move on to first-party property insurance. First-party property insurance, Shant, why don't you talk about the basics?
Sure. First-party property insurance is when you're making a claim with your own insurance company, which you've paid policy premiums for. And typically at least in a residential property policy, you'll have 4 different coverages: dwelling, that's the actual structure that you live in, other structures, sometimes garages and things like that, and even gazebos, things like that will fall under other structures. And then you have personal property, which are your belongings, the contents of your home. And then loss of use, the limits for how much you can get per month, and it's split up in different ways for when there is some type of loss and you need to be out of your home. And in fact, there's some types of loss of use where you can still be in your home and you can recover the loss of use, because it depends on the specifics of that coverage. The only thing I'd want to say on this is, if you are looking at a potential claim and you're going to act as kind of claims counsel, someone's property's been damaged and you're going to help them make the claim with their insurance company, take a look at what falls under other structures and dwelling and things like that, because sometimes there's some nuances there.
Right, and usually other structures is a percentage of dwelling.
Right.
Dwelling, an example of other structures would be a detached garage, a shed, a pool house, something like that. A dwelling is obviously where they live. I will tell you this, that 90+% of people in California are underinsured for their homes and their residences and their business. And there is no liability, almost never, against a broker for underinsuring you, or a carrier for underinsuring you. It's a sad quirk in the law. We don't look at insurance brokers, insurance agents, the same way we look at professionals, other types of professionals. And really what exists in California is what I call a don't ask, don't tell policy, which is, if you don't ask your insurance company if you have enough insurance, they have no obligation to tell you. So you have to find out, because you will, if you have a client with a total loss of their home or their business, I almost guarantee you they're underinsured. And one of the reasons people constantly ask me this, they say, why is it in California that insurance companies don't want to insure people for the full amount? I mean, couldn't they make more money? The answer is the most expensive insurance is your first, say, $50,000 of insurance. And after that, additional insurance is very inexpensive. That's because most claims that are ever made on a homeowner's policy are in that $50,000 range. They're smaller claims. So if you go out, if you have $1 million of coverage on your home and you want to get $2 million, you want to increase it by $1 million, it's not a lot of money. So insurance companies don't want to sell you that, because if you have a major loss like these folks have had in the Woolsey fire and the Camp Fire, these massive fires that have existed in California, they're underinsured, and the carriers don't have to pay out more than the amount of insurance because there's no liability to them. And the insurance lobby is so powerful in California that we cannot change this rule. We can't change the rule about the $15,000 minimum limits, which is over 40 years old. We are stuck with the amount of insurance that you have. People oftentimes will not have enough insurance, even if they have what's called extended replacement cost, 50% additional, 100%, 200% additional coverage. You oftentimes will not have enough insurance. I'll bet you most of these people that lost their homes in Malibu and on the other side of the hill in Agoura, in those areas, I bet you most of them are underinsured. In fact, I know for a fact from talking to people and going out and doing community meetings that people were underinsured.
Yeah, we actually have some of those cases, and we vet them at least sometimes. And when we talk to the potential clients, we tell them, well, do you have insurance coverage? And they say, yeah. Well, what happened? And they said they already sent me a check for the full limits, and it's barely enough to remove the debris and kind of do the tear down for the house. Yeah. So there's
It's very sad.
Widespread underinsurance. So other things to keep in mind about property insurance policies. There's something called the 165 line policy that originated in New York, where at some point insurance companies were getting really kind of slimy about this. So legislatures started to say, no, fire policies have to look like this. And the original one was, I guess, 165 line policy. I think New York was the first one. And that kind of spread throughout the country. California also has it. I forget the code section off the top of my head. I think it might be 798.15. I'm not sure, don't quote me on that. And Insurance companies, they don't necessarily have to copy that, but they have to provide at least the coverage that those policies provide. And we're not talking about dollar amounts, but we're talking about, there's a fill in the blank for the dollar amount. You can contract for $1 or $1 billion. We're talking about everything else, the different requirements of the policy and the exceptions and things like that. Sublimits. There are some sublimits that are enforceable, like the mold sublimit, for example, no more than $5,000. You discover mold in your house, too bad. And sometimes we find them to be unenforceable, smoke and ash sublimits. You'll see policies, and maybe you'll start coming across this now with the wildfires that say if you have smoke and ash damage that was caused by a wildfire, aside from trying to screw you by lowballing you, we're not going to cover it more than $5,000 because we put this little fine print in the contract. And we've actually had courts rule that that's unenforceable, and that they can't do that because it violates the standardized 165-line policy rule, because you go out and buy $250,000 worth of coverage, and all of a sudden you find out that ash and soot rained down on your house for 2 days, and all you can get is a $5,000 check, when you were thinking, well, I have a fire policy that covers $250,000. Endorsements, you can have, you'll come across policies that have specialty items like jewelry or electronics and things like that. If it doesn't, your client there might be kind of screwed, and they might be in the right to deny coverage for some of the items. And additional insureds. If you have maybe a commercial policy where you want your tenant to be added as an insured and protect certain things that they have, there's policies require certain procedures be followed. So you got to make sure that your client or potential client kept up with those procedures.
So one thing everybody should understand about insurance cases is that the insurance code usually provides you with a ton of information, most of it meaningless, but sometimes there's gems. For those of us old enough to remember, 790.03H5 used to be a spectacular, helpful area, because before a case came down in 1988 called Murati Shalal, 790.03H5 under a case called Royal Globe allowed you, if you were the third party claimant, allowed you to sue the insurance company directly for bad faith. Doesn't exist anymore. Don't want to dwell too much on that. But 790.03H5 and the whole H series provides a number of standards for adjusting claims, such as you must pay claims when liability becomes reasonably clear. You have to pay undisputed portions of claims. That you can't force an insured, for example, to file litigation to get money that they're entitled to. That's a great source of information, the 790.03 series. The insurance regulations that were promulgated probably over 20 years ago now are also standard claims practices, such as the amount of time that a carrier has to handle a claim, the responsibility to provide you with a copy of the claims file, the amount of time they have to send before they have to send you letters explaining to you what's going on with your claim. And I urge people who are handling these kinds of claims to read those. Policy conditions exist under the terms of the policy, and I just listed a few of them here. Oftentimes, there is a requirement for filing something called a proof of loss. However, a proof of loss is a form that people are supposed to submit in so many days about their claim, how much their claim is, how much their claim's worth. Courts have generally held that the failure to submit a proof of loss does not prevent you from claiming under the policy. An examination under oath is actually a deposition. Has anybody here had an experience, besides you, Jeff, with an examination under oath? So an examination under oath is when an insurance company says, as part of the claims process, you're not in litigation, you're just pending in the claim. They have the absolute right to take the statement of your client in a deposition format under oath. And if you refuse it, that is a policy condition that's fatal. You will lose your client's right to their policy. And I've seen people before say, well, I'm not doing that. That's just harassment. You absolutely have to do it. And finally, under statute of limitations, policies, yes, sir.
But you're allowed to have your counsel there.
You can have your counsel there. I believe you have the right to prevent them from asking improper questions that wouldn't be proper in a normal deposition. For example, personal tax returns are privileged in California, right? Everybody knows that. They can't, in the context of this insurance claim, ask you for your personal tax returns. So they can't do things that I believe they couldn't otherwise do. but they can take your examination under oath. Can they take it for days and days and days? At some point, I'd say absolutely not. Can they ask you questions of a personal nature that have nothing to do with the claim? I'd say object. But they have the right to take that statement, that examination under oath. Statute of limitations. Policies are allowed to have an internal statute of limitations, a clause in there that's sometimes called suit against us, suit against the insurance company, of no less than a year. So normally what it'll say is that any lawsuit against us or over a claim under this policy must be filed in 1 year. The courts in California, and the seminal case, at least in my back of my brain, is called a case called Prudential LMI. The seminal cases in California have said that 1 year statute of limitations is told from the moment you file your claim until the moment the claim is unequivocally denied, closed, rejected, whatever, paid by the insurance company. So it is not a true year. But you have to be careful of it because everyone in this room would probably, if you didn't know insurance law, you would probably think that you have 4 year statute of limitations under a written contract. You don't. You could have as short as a year if you open the claim on, what's today, January 16th, and on January 17th they close the claim. You're going to have until January 17th of the following year to file a lawsuit. And if you don't do it, your claim could be time barred. But shorter than a year, that's going to be prohibited. The statute's told while the claim's pending. So it's, the courts have looked at this and said, hey, that's a pretty harsh rule, and they've given some leeway to it, but be very cognizant of that statute of limitations. Okay, let's talk about uninsured motorist and underinsured motorist. And I'm going to set this up, and then I'm going to let Shant, you talk about the basics, and then I'm going to talk about why I think you have to be careful of this. As a rule, I do not like insurance bad faith cases that come out of UM and UIM, as a rule. And I think I get calls all the time about this. I think that the way the UM-UIM statutes are set up, the way the process is set up, is it almost never leads to a great bad faith case coming out of an uninsured motorist or underinsured motorist claim.
Because of those reasons right there. You might get stuck in binding arbitration. You're never going to get more than the limits, the UIM limits, and you're limited to the actual economic loss, what you've actually lost. No like bad faith damage.
And this is important. Now, remember everything that Shant and I talked to you about when it came to opening the lid of a policy, blowing a policy open. How do you do that? How does that work in third-party context? Forget it. It has nothing to do with UM-UIM. Just because you made a limit, a demand for them to pay the $500,000, and then you go to trial or go to arbitration and you get $1 million, you don't get to turn to the insurance company and say, you now owe me $1 million. It doesn't apply in first-party UM-UIM. And the reason is the same rule that applied for popping the policy open, you're trying to protect the insured, you're trying to protect the person who's being sued, has nothing to do with this whatsoever. It doesn't mean they can't commit bad faith. It doesn't mean that they can't act unreasonably. We're going to talk about that. But you do not get to exceed the amount of your UM-UIM.
You're the insured here. You're the one that has the relationship with the carrier. They're not exposing you to excess judgment. You're the one that's saying, I'm injured. My carrier, please pay me.
So what if an insured, and this is where I'm really getting into this, what if an insured has been fully paid and is now arguing about the undue delay? So I'll set up a couple hypotheticals. It takes a year before they pay the policy limits under a UM-UIM claim. It takes a year, but you got the policy limits. Or you have to go through an arbitration and you go and, it takes 2 or 3 years to get it resolved. And my God, I had to pay my lawyer a third or 40%, and it's so unfair, and I made this demand way back then. But you're now starting the bad faith case. And the first thing the jury hears in the bad faith case is Mr. Smith has been fully paid his policy limits under his uninsured motorist coverage. That's the first thing that the jury hears. The second thing the jury hears, or maybe even hears from you, the plaintiff's lawyer, is Mr. Smith had to hire a lawyer, Mr. Smith had to go through an arbitration, Mr. Smith had to pay, lawyer fees and costs and expenses associated with this. I'm not telling you it's always true, but almost always the jury doesn't give a shit. And the reason is, in our system, those jurors sitting in that box, they've had to hire, or family members have had to hire a lawyer and pay a third of 40%. They've had to go through a legal process. They're sitting in a courtroom now going through a legal process. And you're sitting there whining to them about, in order to get paid my money, I had to go through this process. I agree. The carrier's conduct can be horrible. But the juries are going to listen to that and go, so what? So, go to the next slide.
Back to this.
And, does it fly in here in the next one? So I am the inventor of a new standard in California called the articulable harm standard for uninsured, underinsured motorist cases. You will not find this in any law book. You are getting privileged information here tonight. No, and the reason I say this is because I don't think you'll ever have a good UIM case in bad faith unless you can articulate the harm that happened to the insured because they didn't pay the claim on time. And so I'll give you a couple of examples. One is, and this is a real world example, is they didn't pay the money to an elderly man who was now in a wheelchair as a result of the accident, and his family didn't have the money to put a ramp into his house and to fix the house so that he could have accessible bathrooms, accessible shower, and there you're able to articulate the harm. Yes, sir.
And that's also an elder abuse case. That's a financial elder abuse case.
It could be. And then you could be entitled to treble punitive damages and attorney's fees. But you're going to have to state this, in my opinion, you guys can disagree with me, but in my opinion, you're going to have to state articulable harm. Another example is the person's out of work. They can't work. They make a demand on their insurance company to pay the claim. Insurance company doesn't pay the claim. They lose their home. Wife leaves. Dog leaves. It becomes a country western song before long. In that case, it is a little delayed reaction of it. In that case, it's articulable harm. But if it's just, it took me a while to get paid, I really had to hire a lawyer, I just wouldn't take that case. I wouldn't take the case. I mean, you got to have something more. You got to have what he said about the elder abuse. You got to have something where you're able to point to it. I just think these cases are more difficult than people think they are. Before we go on to, you can leave it up, but before we get on to that, the one last thing I want to say is that one area I am interested in pursuing, and we've got a case right now that we're about to file, I have for a long time believed that where carriers refuse, so let me give you the hypothetical, and this is, I think, is the actual hypothetical in that case. I don't know if it was a $500,000 or $1 million policy, but the insured had made a demand for policy limits. The carrier comes back and says, well, we don't think it's a $500,000 claim, but we think it's worth $200,000, so we'll offer you $200,000. In property insurance, in first-party property insurance where the house burns down, the carriers have an absolute obligation to pay the undisputed portion of the claim. There's never been a case in California holding one way or another that in an uninsured motorist case where the carrier says it's worth $200,000 and you're saying $500,000, that the carrier is not obligated to pay the $200,000 that they think the case is worth. And I think it's right for an attempt to find out if the carrier has that obligation. So the carriers offer $200,000, you say $500,000. What happens right now, and I'm sure those of you that have handled these cases in the past, is the carrier said, you don't want our $200,000, screw you, we'll now go to arbitration and we're not going to pay you anything. I think carriers have an obligation to write a $200,000 check. I could be wrong, but I think that's the law, and we're going to test it. So if you ever come across a case like that, let me know. Shant, talk about first-party health, life, and disability.
So situations that might arise under life insurance policies are, the number one example we see in life insurance cases is where the carrier says, you had something that you didn't tell us about, and if they really did disclose it or they should have known about it, you might have a case there. But that's few and far between that we come across that. health insurance, disputes arise, and these are super technical. There isn't a very well-developed body of law around these because it's super technical. It really depends on the policy. So you might have situations where they don't authorize some type of treatment. You might have situations where they contend that the treatment isn't necessary, and you might have treatment where they make the physical condition of someone worse because of their delay. And that might be an ideal case because that might be further articulable harm, as Brian says, for bad faith, even though we're no longer talking about UM or UIM cases. Disability insurance, and we've come across this in a couple of scenarios. The insurance company will argue that, well, you're not actually disabled, you're able to do certain things, you no longer qualify for the disability, we're going to cut you off. They might even try to claw back things they've paid in the past. So you might have a dispute over there, and that might lead to bad faith.
Okay, so we generally in the insurance world, we lump health, life, and disability together because of no other reason, because of ERISA. There's a series of cases that came down from the United States Supreme Court long ago that said that ERISA cases, you can never sue an insurance company for bad faith if it's a policy that arose under ERISA. So what's ERISA? ERISA is a health, life, or disability policy that you got as a benefit of your employment, to make the rule kind of straightforward and simple. So if you're employed or you're even the employer and you buy it as a group, you can never sue the carrier for bad faith. In fact, it's worse than that. You have to sue the carrier in federal court. You have no right to a jury trial, and it's a bench trial. And federal judges are so awesome, aren't they? They're so kind, most of them, and they're willing to give plenty of their time, particularly to a bench trial, over something like unpaid insurance benefits. So you can just imagine how fun that kind of case would be. But there are exceptions to this. If you get a health, life, or disability case that comes from an employee who is a public employee, ERISA doesn't apply. A church employee, I've always thought that one was interesting. I think it's something to do with the First Amendment. A church employee, ERISA doesn't apply. Or a employee whose employer collects the money as a pass-through. So that would be the situation where, if Shant had a good job, his employer might pay his health, life, or disability. But if Shant, some do. But if Shant had a job where his employers were sort of greedy and self-centered, they might just tell Shant he can get insurance, but it gets deducted from his check. So it's just a pass-through. Actually, you get your benefits paid?
Benefits?
Yeah.
So
Yes, sir.
there's one other thing you should mention about ERISA is that there is an administrative regime that you must comply with, and any evidence that you ever intend to introduce in that case, ever in the subsequent court trial or not, must be before the administrative body. Otherwise, you'll never get to introduce it.
Right. In other words, if it's not in that claim file, for lack of a better term, it doesn't exist, and you have to exhaust your administrative remedies more often than not, correct?
Right.
And so, unfortunately, there are good health, life, and disability cases that will come in your door. But one of the things, we didn't do a lot of this tonight because of the press for time, but one of the things to consider in intake when you're intaking potential cases is kind of a series of checklists. One of the things we do, we have my partner in the back, Anastasia Mazzella, and Narine Vartanian, who's one of our lawyers, work on intake in our firm. And one of the things we constantly say is, intake is more about disqualifying a case than taking a case, because you're trying to figure out early on whether there's a reason not to take it. And when these health, life, and disability cases come in, there are great lawyers in town who do ERISA. We don't. I mean, very rarely would we touch one. So we want to find that out quickly. All right, so now we're getting into the fact that you've decided to take a case, you have a case, and we want to give, for the last 15 minutes or so here, we want to give some tips about litigating an insurance case.
So this is about drafting the complaint. Obviously, you got to know who's listed on the policy. You can't imagine how many times I've seen cases filed, bad faith cases filed, where they'll list someone who's not on the policy, or it'll be a business policy. They'll list the individual, and they're nowhere on the policy, and they'll list them in the complaint. So you got to always look at that. We've also seen cases that people have tried to bring on behalf of who they thought was an additional insured. Turns out they're not an additional insured because they didn't follow the procedures that we were talking about earlier. Know the types of coverages, know what you're alleging, attach the policy as an exhibit to the complaint. Actually, in the back of your packets, I think there is a good example of a bad faith case, and it's a super interesting one. Wildfire case. It involves smoke and ash. It involves challenging the endorsement, but it also involves the claims handling.
Did you draft the complaint?
I think so.
Oof.
Yeah.
Well,
So
be
I can't.
careful,
I can't
folks.
promise. Yeah. Yeah. Actually, let's all rip it out and throw it away. No. So attach it as
We kid.
an exhibit. In the sample you have, I don't have it attached because I didn't think you'd want an extra 60 pages. Name the right insurance company. They'll always come back to you sometimes if you name their the flagship name, like if you name Farmers Group, they'll come back and say, well, this isn't the one that really issued the policy, and tell them to go file a demur or something, or tell them to go file an MSJ because they can't demur on those grounds, because they just don't want the high-profile name there later on because it kind of vilifies them more. Keeping it out of federal court. I think Brian today was telling me something interesting about new authority out there that lets you possibly name the adjuster that will help you keep it out of federal court, because oftentimes the carriers will be out of state. Your client will be in California. You have complete diversity. They can
There's a
just remove it
reason
and-
insurance companies remove cases to federal court, and it's not because they believe in Article 3 of the United States Constitution. So I don't like being in federal court. I don't like the unanimous jury. I don't like the fact that I think federal judges oftentimes are trying to clear their docket. I like the fact that you try cases in downtown Los Angeles, insurance cases, you get better juries anyways. There's so many reasons to keep it out of federal court. I've also seen complaints that are overpled. I mean, generally speaking, as a plaintiff, I usually don't file a cause of action for declaratory relief. Your breach of contract is enough. I file a breach of contract cause of action, usually a bad faith cause of action, breach of the implied covenant, in other words, and sometimes a 17-200, and that's about it. I've seen bad faith complaints filed before that are kitchen sink complaints, and you don't need it. Your bad faith cause of action is such a good cause of action in California. It really catches everything you possibly need outside of the breach of contract cause of action. And so keep your complaint simple. Carriers always demur. I mean, they also always demur, but you're going to have a much better time if you keep your complaint simple.
Question?
With the exhibit, if you have a case like mine where you have multiple parties, you attach each policy of the plaintiff, or if it's against, let's say, AAA and they have one uniform policy, is one enough?
I think you would just attach to one as an exemplar, especially if it's a major carrier. They'll probably have the same form. If all your clients have that, but just attach one as an exemplar is what I would suggest.
Yes.
So I've heard that when you file a bad faith complaint, you should include the debt relief action because you want to find out whether there's coverage before you put in a lot of money into working up your case. So can you give us your thoughts as to why?
I don't know why. I wouldn't do that because you've got a breach of contract cause of action anyways. And under the MSA, MSJ statute, you can file a MSA based on whether or not there's a duty or whether or not there's a viable contract. I just wouldn't do it. I think there's no point in doing it. Look, there's exceptions to every rule, but I really feel that I wouldn't file that kind of claim. And you and the carrier, honestly, a lot of lawyers that represent insurance companies, all joking aside here, a lot of them are smart lawyers. Like I always joke, insurance companies will go out and hire somebody, and I don't mean to insult anybody here, I'm just being kind of blunt though. Insurance companies, when they're filing a lawsuit or defending a lawsuit on behalf of their insured, they'll go get sort of a run-of-the-mill insurance defense lawyer. But when they're being sued, they'll go get really good lawyers. And the reason I say that is because a lot of times if there's a real legitimate coverage issue, call up the lawyer on the other side and say, look, I know you think there's no coverage, we think there's coverage, let's tee this up and let's get it resolved. So I wouldn't file the debt relief action. Evaluating your case never ends. I know we're going to run out of time here, but I want to run through a couple of these points with you folks. By the way, if I didn't say it before, I really appreciate you coming in the rain tonight. I appreciate you coming down here. It's this is Southern California. I was watching the news this morning, and I was watching what's going on back in the East Coast with the just horrific weather conditions, and I thought those people are coping better than us with a slow drizzle here in Southern California, right? Somebody here tonight, I remember, which one of you guys, you came from Woodland Hills of the Valley, right? It took you an hour and a half to come downtown on an evening. So thank you all very much for being here. Evaluate your case. Look, here, I kind of mentioned this earlier. I know this is shocking to you, but clients sometimes lie, right? And sometimes you'll get involved in a case and you'll find out it's not as good as you thought it was, that there were some facts. So keep evaluating your case. How's the best way of evaluating your case? Well, the best way of evaluating your case is as soon as you file that complaint and the first opportunity you have, submit a demand. That's your cue. That's your cue. Your cue. Your cue.
Oh, next.
Thank you.
Yeah.
Submit a demand for the claim file. The claim. Now, when Jeff and I were baby lawyers, they actually had paper claim files, which is really, really bad because a lot of times you would demand the file and then they'd tell you later, oh, we just talked to our office in Toledo and they actually have a file and we weren't aware they had a file. But today, so much of claim notes and so much of what happens is paperless. And it's usually a good thing because you can get the whole claim file and you get it early. And the minute I get this claim file, Shant, what's one of the first things I insist on when we get a claim file?
Print it out and read it.
In chron order.
Oh, put it into chron order and then read it, yeah.
Then sit there and spend a lovely Saturday by the fire reading the claim file.
And it usually turns up in chron order. They produce it in chron order, claim notes, claim file. Yeah, sometimes they kind of mess with you, but yeah, if they just do a doc dump of emails, it's not going to be in chron order. But if it's the claim notes, things like that, it'll be in chron order and it'll give you a good overview of what's happening.
Yeah, I mean, it's not as easy to read as it sounds because
right.
They have these weird programs about claim notes and it's a little confusing, but God, it is so important to read that because what I'm looking for is what they were doing, what they knew, what the timeline was, how much delay there was, and then what I'm really, really looking for are nasty letters, comments, calls from your insured, from your insured's representatives, from your insured's family, because it makes me cringe sometimes when I see things that people write. They don't obviously think it'll ever appear on a screen in a trial. But I want to know that claim file early on because that's the most important way to evaluate it. And don't just demand the claim file. Demand the underwriting file. Demand all their claim notes. I think did you include a request to produce documents in our materials?
I did, yeah.
So that's a really good thing to do. Get them as quick as you can. This is interesting. Advice of counsel, attorney-client privilege. So I don't know if you're all familiar with the advice of counsel defense. It's not an affirmative defense. It doesn't have to be pled. So carriers will oftentimes rely upon advice of counsel as a defense, which is a defense to bad faith. It's not a defense to their contract. It's a defense to their bad faith. It's a defense for them to say we act reasonably because we went and hired a lawyer and a lawyer gave us advice and here's what the lawyer said. Now, there's ways to undermine that. You can find out the lawyers in-house. You can find out that they get most of their bread is buttered by that particular insurance company. But I'm going to ask questions early on about whether or not they intend to assert the advice of counsel defense. They will try to weasel on it. Not at this time. We don't know. And I want to file a motion on that, or I want to get an agreement from them on that issue, because the minute they raise advice of counsel, they no longer have the attorney-client privilege. So you then can depose their lawyer, and the lawyer would have to turn over all the notes and communications with the carrier, plus you can take depositions of them. So I want to find that out quickly if they're going to raise advice of counsel of defense. Another side issue on this is it's not unusual today for insurance companies to employ lawyers who don't need their bar card to do what they do at the insurance company. So they're just acting as a claims adjuster. You don't need a license to practice law to be a claims adjuster at an insurance company. But insurance companies like to do that, particularly with higher values, more sophisticated claims, because they then will say every communication from that lawyer is privileged and we're not going to turn it over. Fight them. Because you get in there and show that person could have just as easily been unlicensed to do their job. you probably can get some of those communications and not all of them. Make a detailed chronology, work on your chronology, know what the facts are, get the claims handling manuals. Usually they're spectacular. They almost always will have a statement in the beginning of a claims manual about the mission of the insurance company. Our job is to help our insured and to do everything we can to help our insured get their claim paid in a timely manner. Blow it up and use it at trial and keep asking the witness, so is this how you were trying to help your client, your insured get the claim paid in a timely manner? I don't know if anybody here has a working knowledge, besides Jeff, of colonial life discovery, but there is case authority in California that under certain circumstances will allow you to get similar claims to determine whether or not there is a pattern and practice of claims handling. So you can find out other claims that involved water loss or other claims that involve this provision of a policy, and if you get the order, the insurance company, it will drive them crazy because they hate turning over other claims, and you can then develop a pattern and practice. Very important, we haven't talked a lot tonight about punitive damages, but in the golden age of insurance bad faith, before the Campbell decision came down from the United States Supreme Court, you could have a relatively small value claim and get a huge amount of punitive damages. My first insurance bad faith trial I ever had was about 25 years ago with a $35,000 loss, and I got $1 million in punitive damages in that case. Couldn't do that today because of Campbell, because of the multiplier for compensatory, although I think if we get a minute, we'll talk a little bit about some exceptions to that. But one of the things Campbell says is, and its progeny is, one of the ways you should be able to get punitive damages in a case is to show that it's part of a bigger pattern and practice in a company. So that's one of the reasons I think enhances colonial life. Look, the rest of the stuff here is pretty straightforward. Interview clients, interview people, do your work, get the case worked up, don't wait until the end, take depositions of the claims adjusters, the claims representatives, the supervisors, people at the company. Know your case before you start those depots. Don't go into them without having that entire claim file. Don't do anything in the case until you have that claim file.
Expert witnesses. You can hire someone that's an actual claims handling expert, an insurance expert. You can hire an underwriting expert if that's an issue in the case. Damages expert, that's kind of like just a broader term for someone to quantify your damages. And a specialty expert, if it's some particular type of loss, water loss or a fire loss, you're probably going to need someone that specializes in that type of determining the source of a fire, let's say, if that's an issue in your case. So they all have, it's kind of formulaic. They have, some of it is kind of going to be repeated in all the cases, and sometimes you're going to need something unique about each and every case. So these are the damages that you're entitled to. Obviously, the first category is the contract benefit, whatever is owed under the contract. Separate from that, and there's usually a separate box for this on a verdict form, is the bad faith damages. So you can get, and this, you shouldn't mix up economic damages with the unpaid contract benefits. You can get economic damages as part of the bad faith. It's whatever you had to expend in order to make yourself whole, or whatever damage you sustained, monetary damage you sustained as a result of their conduct in breaching the contract. Non-economic damages, that's pain and suffering, anxiety, stress, humiliation, things like that, and you can kind of go over that. In trials, oftentimes, what we've done is break up each category. I believe it's 3904A, the Casey instruction, and it just has a list separated by commas. We just separate it out and list them line by line, and we go past and future, and we ask them to assign $1 for each. The verdict form just has one box, but when you break it up like that, it's really effective and goes a long way. Grant fees, those are...
We'll talk about that next.
We'll talk about that next. And then punitive damages, we kind of touched on that already. So,
all right, so this is a unique issue in insurance bad faith. If you get to bad faith and the jury finds bad faith, the jury can award your client their attorney fees for securing the unpaid portion of the policy, okay? So it is not a statute. It doesn't exist in the contract. Your insurance policies usually don't say prevailing party gets attorney fees. But this case called Brandt versus Superior Court said that if the insured committed bad faith, and as a result of that, you had to hire a lawyer to secure your unpaid benefits under the policy, you can, if the jury agrees, get your attorney fees. Now, what I often do with this is put a box for the jury to check that says we want the policyholder to get their attorney fees and not put the jury in the position of having to actually decide the amount. If the defense doesn't agree, the jury might have to make that determination unless the judge can persuade them. I much rather would have a judge decide the amount of my attorney fees than have a jury who doesn't have a complete comprehension about how expensive it is to litigate cases. And here we get into a little nuance. I don't know if that's in the next slide or not. Yeah. The easy one is Brandt fees are supposed to be calculated based on your contingency fee agreement. That's one way to argue it, is that it should be based on your contingency fee agreement. But I have had success in convincing judges that where the amount of unpaid benefits under the contract is relatively low, say a couple $100,000, and my fees might be 40 or 45% of that, I've convinced courts, well, wait, there's nothing that says you should be limited to your contingency fee. Why shouldn't you be able to recover your hours?
And I've actually included a sample of a motion where we were really successful in doing that, because we had, I think, $100,000 in contract benefits, and if we were limited to our contingency fee, we just get 40 or something like that out of it. But we put a ton of hours into the case, so we argued that we should be able to get it based on our hours. And the law isn't very clear on this, so you have to make that argument. And we were able to get, I forgot what the number was, but it was close to $500,000 probably. And there's a tenfold difference there.
I mean, this is just normal for any case. Most defense lawyers will intelligently bifurcate. I once had a case where the lawyer didn't bifurcate, and the judge said to him, I know you're not bifurcating. You think that your insurance company is really small because their net worth is only $50 million. And the judge said, but you should look at that jury. None of them have seen $50 million before in their life, and they have no understanding of what that means. So it's a mistake for them not to. They'll almost always bifurcate the case. That doesn't mean you can't talk about punitive damages during closing argument or during the first part of the case, saying that fraud, oppression, or malice is the gateway to punitive damages. You're not determining this case, but in order to get to punitives, you've got to find fraud, oppression, and/or malice. And then the jury instructions here are very helpful. If you're in a case like this, even the case we just did, which is not a bad faith case where we got a lot of punitives, we blow up the jury instructions about what is fraud, oppression, or malice, despicable conduct, what it defines and how it defines. And you also have to establish that the conduct was ratified by a managing agent of the carrier, but that's fairly broadly defined in California law. But be aware of that, because they'll try to say, well, the higher-ups in the company didn't know about it, they didn't know what was going on.
So there's an interesting relationship between attorney fees and punitive damages. And this goes back to what Brian was talking about under Campbell. The controlling case law on the ratio of punitive damages to compensatory damages is BMW versus Gore. In that case, it was ruled that punitive damages can't be grossly excessive. I think that's the term, grossly excessive. And generally, you get a presumption of grossly excessive if the ratio of punitive damages to compensatory damages is greater than 10 to 1. You have exceptions, and it's really up to the trial court whether or not they're going to reduce it, but generally that's presumed to be excessive. So this case called Nickerson came along in 2016 and said that you can include, in insurance cases, you can include the Brandt fees, the attorney fees, in calculating the amount of compensatory damages when you're trying to look at that ratio. So if you have $100,000 in, let's say, contract benefits or compensatory damages, contract, economic, non-economic, all of that, you have $100,000 total, and you have let's say, $1 million punitive damages award, you're kind of cutting it close because that's 10 to 1 right there, and you might get reduced. The punitives might get reduced. But let's say you successfully bring a attorney fee motion, and you win $400,000 on top of the 100. So now you get to use the denominator of $500,000 instead of being stuck with the $100,000 that you were awarded as compensatory damages. And there's an argument, we're testing this now kind of, that you can apply this principle to other types of cases as well, not just in Brandt fees. So we'll see how that goes.
So I think this is our last slide. and I just want to caution everybody, reevaluate your case all the time. Even if you're not referring a case to us or you're not referring a case to somebody else, feel free to call somebody who does this on a regular basis and pick their brain, go over the facts with them. Look, I'm just like everybody else in this room. I get involved in my cases, and sometimes I fall in love with my cases. And I find myself, so enamored with the clients or so enamored with the facts. I think I've got the greatest case in the world. It's not always as good as you think it is. And if any lawyer tells you that every case they've always had has been a perfect case, that's only because they've handled one case. Because I will find myself constantly asking people what they think about my case. My partners and my lawyers here will tell you that sometimes I'm the worst judge when it comes to cases that I'm looking at myself. You need to be objective about it. Facts will pop up in your case that are good or bad. When I was a very young lawyer, I learned the Goodman rule. I only think it was called that because the guy who created it, its probably name was Mr. Goodman. And that's that good cases get better, bad cases get worse. Be careful. If you start finding yourself in a case where it is, you've experienced this, I can tell, where you will find yourself getting sucked into a vortex and your case gets worse and worse and worse, and you're sitting there trying to explain to someone, but it wasn't a felony conviction. He's not that bad. Look, if you can't explain I'm serious about this though, if you can't explain your case in a 30-second elevator ride and convince a non-lawyer that it has merit, or you've got to be explaining yourself to people all the time. You get into mediation, a good mediator sits there and tells you that they've got some questions about your case and you're going humana. Be honest with yourself. There may be problems with it. When I started, I assume most of the people in this room who are practicing lawyers do contingency fee work. When I started my own firm almost 20 years ago, and I was, and almost have always done exclusively contingency fee work, somebody told me, you will have no shortage of people who want you to represent them for free. And that's true. So there are people who have no skin in the game that will want you to continue on with their case. Don't make the mistake of overlooking bad facts. Don't make the mistake of not getting out of your case in time, because the best time to get out of a case is before they sign the retainer. The next best time is before you file the lawsuit. And then the next best time is any time well enough before trial so the client isn't screaming about being abandoned and some judge is forcing you to try a case. And really, these cases are not as expensive as some horrible personal injury case where you sink $200,000 or $300,000 into the case before you start trial, but they're expensive, and especially when you get into experts. So open to questions. We're happy to entertain any questions. You guys have been really good to sit here. Yes, sir.
This question relates back to the demand and getting too queued and setting up insurance companies. Have you ever ghostwritten a demand for a client, or would you ever recommend doing so?
Sure. You mean where the client themselves is going to send the letter saying, please pay me the policy limits or whatever? Sure. Sure. I don't think that's a bad idea. I think that it's perfectly fine to do that, and I think that if what you're trying to, I get what you might try to do there, that see if the carrier is going to take advantage of them. I'm not sure that's setting them up. What I'm more concerned about with setting them up is not giving them all the facts, is kind of hiding the ball. So I don't think there's any problem with saying, hey, my son was critically hurt in this accident and is in the hospital, been in the hospital for 2 weeks. You only got a $15,000 policy. We demand the full payment of the policy. We'll give you the release. As long as it meets the same standard, I think that's okay. Anybody disagree with that? Anybody here? Smart people here? Okay. Next question. Fanny? Yes, sir.
Well, along those lines, if you had, 500 pages of medical records, horrible injuries, but you send them just 1 or 2 pages with the police report, and it's obvious that it's worth more than the policy limits. So a lot of people talk about setting up the insurance company that way because really the injuries are worth a lot more than $15,000. Is that something that you would say just definitely don't do it, give them all 500 pages, whatever you have?
Look, I wouldn't do it because imagine yourself now in the deposition and you've gone to trial on that case and you've got an excess judgment and now there's a bad faith case pending and now you're in the witness box and you're being asked a question. The first question I was going to say is, can you just explain to us, you had all 1,500 pages of those medical records, didn't you, sir? Yeah. Is that a yes? Yes. And you made a decision only to send a couple pages, is that right?
Yes.
And so the reason you didn't send the rest of them is you wanted to just set the insurance company up. You wanted to hide the ball, didn't you? So, but there must be a good reason why you didn't send 1,498 pages to my client. Was there a good reason?
Save trees.
Okay. Any other questions?
No, but really, like just today, I was kind of going through demands, trying to pick a good sample to use. One of the ones I came across, it was a PDF that was 600 pages long. I mean, just throw it on there, and chances are you could send them the hard copy letter along with a flash drive that has the records on it, enclosed as a CD that has all the medical records.
Right. Who in here would like a quad case with a $15,000 policy limit where the carrier doesn't pay the policy limits and you go to trial and get a $20 million verdict? Who wants that case? Who wants that case? Yeah. Good luck. I mean, it happens, but good luck. Yes.
If the policy has an additional insured on the policy and you make a demand, and they say, oh, you have to add to the release the additional insured, but the additional insured is a separate defendant, has their own separate policy, so you don't want to release them. So I want to settle with this insured that for their $25,000 policy, but I don't want to get rid of that other defendant who is an additional insured on this $25,000 insured policy, so I want to go after their $1 million policy. Is there a way to open up the policy if they don't pay that $25,000?
From the facts you told me, my gut reaction is probably not, because carrier has a duty to protect their insured, and that additional insured is just as insured as the named insured of the policy. So probably not. There might be nuances to it, but probably not. I know. Question, yes.
Yeah, so you talked about a reasonable time to respond to demand would be about 30 days, but sometimes I run into, like I'll demand the policy and they won't pay, but then something will change. For example, there's a surgery recommendation or the client gets surgery, and so there's one additional fact and a few more records. And if you give them like a few days or a week to reply, do you think that's reasonable in that case?
Might be. Yeah. If these obviously turn on all their own facts. That's the point I'm trying to get across to everybody. Is that's the reason why it's a reasonable standard. But you've given them plenty of information. Maybe you even told them that it looks like there's going to have to be surgery. There hasn't been surgery yet. It looks like there's going to have to be surgery. Then it might be reasonable to send the addition. They blow the deadline, but it might be reasonable at that point to send the additional information and say, he had the surgery. You've had the rest of the records. Here is the verification. You have a week. That might be reasonable. I think yes.
I've seen more and more lately that insurance companies are asking if there's a spouse and trying to include them as part of the release. And if it's a policy limit case and there is a potential loss of consortium claim, how does that play into things?
That might be a reasonable request because the spouse under a loss of consortium claim doesn't have a separate distinct claim. It's part of the same claim. So in order to include them, it might be reasonable. On the other hand, they may not have their own standalone claim. But again, is it unreasonable for the insurance company to not pay, or put it differently, is it reasonable for the insurance company to pay if the spouse is included?
If there are multiple claimants, I know you said earlier that you can't open a policy, but you can kind of get the other side. If your client's claim warrants tendering the policy in and of itself, can you say in the demand, pay the policy and we'll figure it out amongst ourselves?
If you have an agreement to do that. But if there's no agreement, even let's assume horrible facts, you've got that quad case and it's a $15,000 policy, but there was another person in that car, and that other person in the car has a $5,000 claim. You're potentially exposing the insured to excess liability. So it may be reasonable for the insurance company to deny it, saying unless you're both at the table. I'd be concerned about that.
Can you just request that the insurance company tender the policy to all claimants?
You can, but is there any agreement from the other claimants to accept it? There has to be agreement that you're taking the insured out of harm's way.
Can the refusal to negotiate or attempt to sell a policy give rise to bad faith in that situation?
Maybe if you had a fact pattern where you say, look, we want you to reach out to them, you want you to see if the other claimant will agree to these terms and conditions, we're willing to work with you, we're willing to have that conversation with you, and if they blow that off, they don't do any work, they don't do any effort at all, then maybe. There was a Ninth Circuit case that came down about, 6-7 years ago, and for a moment it held that the insurance company, even faced without a demand, has an obligation when it knows the claim is going to exceed the policy to tender. And the Ninth Circuit actually issued that opinion, and I was like, oh my God, that is such a great opinion. And then like sua sponte, within 3 weeks, they reversed themselves. Someone must have called them in the court and said, what have you done? So, you know, that was to me a very clear indication that you have to make the demand, you have to be clear, it's incumbent upon the claimants to make the demand. So look, the problem here is, unless you get a clean case, and we rarely see clean cases, unless you get a clean case, the carrier is always going to have some wiggle room. Okay? Hey, thank you all very much for being here.